Start. Review petitioners seek modification mainly of the sentence awarded to the accused Mr. Sushil and Gopal Ansal as per the orders of this court in the criminal appeals. Stop. It is the main contention of the learned senior counsel appearing for the Central Bureau of Investigation that there is no provision for substitution of sentence by fine. Stop. It is also the case of the review petitioners that both the accused deserve the maximum sentence under section 304A of the Indian Penal Code, 1860. Stop. Having also heard learned senior counsels appearing on both sides, we feel it necessary to refer to the background of the case as reflected in the various orders passed by this court. Stop. In short, the High Court upheld the conviction of both the accused under section 304A, 337 and 338 but reduced the sentence under section 304A IPC, to 1 year rigorous imprisonment, under section 337 to 3 months, and under section 338 to 1 year. Stop. All sentences were to run concurrently. Stop. All convicted persons filed appeals before this court. Stop. Central Bureau of Investigation also filed appeal numbers 605 to 616 of 2010. Stop. The Association of Victims filed appeal challenging the acquittal and for retrial of all accused for the offence punishable under section 304 part 2 of IPC. Stop. Para. It was of the view that additional sentence of 1 year should be awarded, but the same could be substituted by substantial amount of fine. Stop. However, the nature of the tragedy and the negligence on the part of both accused and Delhi Vidyut Board, they should pay a hefty amount of fine for the purpose of construction of a trauma center. Stop. Yet, the fact that Sushil Ansal had served major part of the sentence and considering also his age, the sentence already undergone by him should be treated as sufficient. Stop. Para. A close reading of the order passed by Mr. Mishra, would show that recovery of a large amount by way of fine to be used for the trauma center was the underlying idea in enhancing the punishment. Stop. The 3-judge bench, on reference, also took the view that in larger public interest, the view taken by Mr. Mishra, should be upheld, but reduced the fine to rupees 30 crores each, apparently keeping in mind that the victims had already been compensated and that even, according to him, both accused and Delhi Vidyut Board are liable to pay the fine. Stop. Thus, he and 3-judge bench took the view that as far as accused first, Sushil Ansal is concerned, taking note of his age, related complications, the period already undergone by him should be sufficient, in case he pays rupees 30 crores. Stop. On principle of parity, the same benefit was extended to accused second Gopal Ansal, but he never had a case of any age-related complications. Stop. Therefore, it is not a case to apply the principle of parity. Stop. To that extent, the order needs to be reviewed. Stop. Yet another error is the substitution of sentence by fine. Stop. The order under review, agreeing with the view expressed by Mr. Mishra, the bench enhanced punishment to the maximum period of 2 years but substitute the additional period of 1 year with substantial amount of fine. Stop. The idea was to impose a heavy fine and utilize the same for the benefit of the public. Stop. In a case, the conviction under section 304A was altered to 304 part 2 but reduced the period of sentence to the one already undergone, and the court imposed a fine of rupees 50 lakhs to be used for the benefit of the victims in hit and run cases. Stop. There was also an order on 2 years of community service. Stop.